Hello, and welcome to Healthcare Risk Management Week. This year, we're excited to share a mock trial, which is based on a real medical malpractice case that was tried in 2021. The names have been changed for privacy. This week, we are going to take you through a trial in an abbreviated fashion. We invite you to be the jury, and at the end of the week, you will decide the verdict of this mock trial. This is a case about Ms. Doris Williams, a 62-year-old who presented to the emergency department for rapid heart rate, shortness of breath, and dizziness. While she was there, her condition worsened and she showed signs of a stroke. Mrs. Williams was transferred to UMMC, where she was given a grim prognosis and was transitioned to hospice care and ultimately passed away. The plaintiff alleges that there was a delay in diagnosis on arrival to the ED, a delay in calling a code stroke, and a delay in transfer. I would now turn it over to Judge Alicia Reynolds, who will provide the legal background.
Good morning, ladies and gentlemen. You're here today for a case of alleged medical negligence. As you will hear, plaintiff, the daughter of Mrs. Doris Williams, has filed a lawsuit in which she claims negligence that healthcare providers in the emergency room at a hospital did not timely diagnose that Ms. Williams was having a stroke, which unfortunately resulted in her death. More specifically, the plaintiff is claiming that the emergency department physician, Dr. Lewis, failed to timely diagnose Ms. Williams' basilar artery stroke and failed to timely transfer her for endovascular treatment, resulting in her death. Lawyers for each party will make an opening statement and a closing argument. Each party to the case will testify. You will hear from the plaintiff, Ms. Williams' daughter, Ms. Layla Williams, and the defendant, Dr. Esther Lewis. Each party will also call an expert witness in emergency medicine. As the jury, it is your job to determine whether the plaintiff has proved her claims of negligence by a preponderance of the evidence, meaning more likely so than not so. Negligence is defined as the failure to meet the standard of care, what a reasonable healthcare provider would do under the same or similar circumstances. Whether or not the provider met the standard of care is your decision, and you will be assisted with that decision by the expert witness testimony I talked about. If you find a breach in the standard of care, you must then determine whether it caused or substantially contributed to Ms. Williams' death. If so, you will then decide how much should be awarded in compensation. Before we begin today with opening statements by the attorneys, I am going to briefly instruct you on the law, as is my duty. It is my duty to instruct you on the law. It is your duty to apply these laws to the facts as you find them to be from the evidence presented to you. You will hear over the coming days testimony from witnesses. It is your role to determine the credibility of each witness. In so doing, you may consider the manner in which they testify, their interest in the outcome of the case, and any other factors that may bear upon their credibility. The plaintiff has the burden of proving the case by a preponderance of the evidence. This means that you, as the jurors, must be persuaded, considering all of the evidence, that what the plaintiff is claiming is more likely true than not true. Medical negligence occurs when a healthcare provider fails to follow the standard of care that a reasonably competent provider in the same field would have followed under similar circumstances. For the plaintiff to recover damages, they must prove that the defendant's negligence was a proximate cause of the injury. Proximate cause means that the negligence was a substantial factor in bringing about the harm. If you find for the plaintiff, you must then determine the amount of money that will fairly and adequately compensate them for their injury. Your verdict must be unanimous. All jurors must agree to the verdict. Thank you for your attention. It is now time for opening statements. Because the plaintiff has the burden of proof, the plaintiff will go first, and they will have the opportunity to have the last word as well. I will now turn it over to plaintiff's attorney, Mr. Neil Brown.
May it please the court, Madam Forelady, members of the jury, it saddens me to come here today. I'm going to tell you a very tragic story. I'm going to tell you about malpractice. I'm going to tell you about delay, and I'm going to tell you about something that took my client's life. This is Mrs. Williams, and that's her daughter, Layla, reaching right over her shoulder. Because of the malpractice in this case, Miss Williams is no longer with us. Her daughter, Layla, is, and we're going to tell you a story that will break your heart, but in this world, it's about proving malpractice, and we're going to do that for you today. Before I tell you the story about what happened, let me share two thoughts with you that I want you to keep in your back pocket throughout this trial. The first is, this is an emergency room case. And what do they teach emergency room docs from day one? Rule out the catastrophic. When somebody comes in and they are 64 years old, they have a rapid heart rate, and they're dizzy, you don't just assume it's an anxiety situation. You've got to consider other possibilities. And stroke better darn well be on your differential. Rule out the catastrophic. And what is the second thing I want you to remember as we go through this case this week, members of the jury? Time is brain. And what do I mean by that? When you have a clot in your brain that is blocking the blood flow to the very important tissue of the brain, time is brain. It's killing those tissues with delay. You're going to find in this case, I believe, at the end of this trial, that the delay caused by the healthcare providers at Prince George's County Hospital caused the death of Miss Williams, took Layla Williams' mother from her. And we'll go over what happened in that. Mrs. Williams arrived at the emergency room at Prince George's Hospital about 9:30 a.m. On the 20th of July. She had a rapid heart rate. She was dizzy. She was an older woman. She had no history of these kinds of problems. She was seen by the defendant, Dr. Lewis, who didn't do anything. He ordered metoprolol to slow down her heart rate and left her in the emergency room. Now you're going to hear from her daughter, Layla, who was saying frequently, "What is going on? Who can help Mom? Where is the providers for her?" Nobody came and called the stroke code that the standard of care required. Mrs. Williams stayed in the emergency room. She got a little medication. Nurses came by a little bit. But at 2:00 p.m., the change of condition happened. Mrs. Williams' face went droopy. She was unable to move her left arm. You don't have to be a board-certified emergency room physician to know these are signs and symptoms of a stroke. So she shows up at 9:30 saying, "Help me." They don't do anything. And at 2:00, everybody now knows stroke. Too late. Delay. Malpractice. Dr. Lewis finally calls a code stroke, which is the hospital's policy, finally gets the studies that confirms that she does in fact have a clot in her brain. Now, if you remember, we talked about time is brain. Her brain has been suffering from 9:30. It's screaming at 2:00 that there's death of tissue, that we can't move our arm, that her face is drooping. She begins to get worse. She can't communicate. She becomes obtunded. What is the standard of care? What does a reasonable emergency room physician do under those circumstances? Well, Prince George's County Hospital tells you what the answer is to that question. They have a written policy that explains when that patient is supposed to get the care that the patient needs, when Miss Williams needs to arrive at a facility that can pull that clot out of her brain. This is the policy that Prince George's County Hospital has in effect at the time Miss Williams was in the hospital. And what it says, for good reason, and it's a variation of time of his brain, is that this patient should be transferred urgently and the patient should arrive at the receiving facility within 6 hours from last well seen. So let me back that up and play it a little slower for everyone. Arrive at 6 hours from last well seen. So if you start the clock at 9:30 a.m., they violated their policy grossly. Mrs. Williams did not arrive at University of Maryland Medical Center until 9:37 p.m., 12 hours after arrival. Violation of the policy, malpractice. But if you give them the benefit of the doubt and you start the clock at 2 p.m. when everybody could tell a stroke was going on, and you add 6 hours to that per the policy, Mrs. Williams was required to be someplace where they could care for her properly by 8 p.m. And when you decide this case, as to the jury, I'll ask you, did the healthcare providers, did Dr. Lewis and his team get my client to where she could be cared for within 6 hours as the policy required? And the answer is no. No, they didn't. The judge will instruct you at the end of this case that violations of these policies written by the hospital is evidence of malpractice. And that's what happened in this case. Now, we are the plaintiffs in this case, and we bear the burden of proof. We understand that, and we welcome it. Now, what are we talking about when we talk about burden of proof? We're talking about the scales of justice. I'm sure the defendant's going to get up here and tell you all kinds of stuff of why they couldn't do what they needed to do for my client, but you evaluate it and you put the evidence in the scales of justice. And if it tips ever so slightly in favor of Mrs. Williams or her daughter Layla, even a featherweight, then we met our burden. Now, how are we going to meet our burden? First, you're going to hear from my client, Layla Williams, that's going to tell you about the delay. She's going to tell you about how often she asked for help and how nothing moved fast enough for Miss Williams. She's going to tell you how her mother suffered. She's going to tell you how the loss of her mother affected her. But in addition to Miss Williams, we have called an expert. We're going to call an expert witness, Dr. Gaynor. Dr. Gaynor is a board-certified emergency room medicine that's going to share with you her stories of thousands of stroke patients, caring for lots of patients that have the same signs or symptoms of Miss Williams. Dr. Gaynor is going to tell you that this case is a malpractice case. She's going to tell you that the standard of care required that Miss Williams have a code stroke call when she showed up at 9:30 in the morning. The dizziness is a sign of a basilar artery occlusion. That is fancy terms for there's something going on in the back of the brain, and you darn well better rule out the catastrophic, which is stroke. They breached the standard of care by not calling a code stroke that time of the morning, not getting the proper studies, and certainly by not getting Miss Williams to the place where she needed to go timely. Dr. Gaynor is also going to tell you that they too have a policy at her hospital, and theirs is 6 hours. They've miserably failed to comply with their own policy of transferring Mrs. Williams timely. Now you ask yourself, well, this is a clot in the back of the brain. Isn't that bad? Yes, it is bad. But if you treat these clots timely, patients can survive. And if you don't, time is brain, and when you have enough trauma to the brain, you die. And in this case, Miss Williams lingered for about 4 days and then died. Dr. Gaynor will tell you that the breaches in the standard of care by Dr. Lewis and his team at the hospital were the direct and proximate cause of Miss Williams' death. Mrs. Williams deserved good care. She deserved reasonable care. She did not get it at Prince George's Hospital. Our expert will tell you that there was malpractice that caused this death. In the end of this case, we will submit to you a verdict sheet that says, asks you whether there's malpractice and whether it caused the death. And the answer to that is going to be, I believe, unquestionably, when you look at the scales of justice, yes. And then we will be asking you for compensation, fair compensation, because that's all our justice system allows us to do. We can't bring back Miss Williams to her family. No more Christmases, no more graduations for the grandchildren. Nothing can ever replace her, but in our system of justice, we will be seeking compensation. Delay, delay, delay. So I leave you with these two thoughts. Rule out the catastrophic. Take care of your patients the way you would want your family to be taken care of. And time is brain. And if you delay enough, you're going to kill someone. And they killed Miss Williams in this case. I appreciate your patience with my presentation of the case. I will be going forward first, and then the defense will be going, and then I'll have a chance to do closing arguments at the end of the case. So I appreciate your time and being on our jury. Thank you.
Ladies and gentlemen of the jury, good morning. My name is Michelle Dion, and it is my privilege to represent my client, emergency medicine physician, Dr. Esther Lewis, in relation to care that she provided to her patient, Miss Williams. You heard a lot from plaintiff's attorney about delay and malpractice. This case isn't about delay. This case is about a devastating stroke in the back of the brain, a basilar artery occlusion. And you'll hear this referred to as a brain catastrophe or a bullet to the brain. And it's also about an emergency medicine physician who acted timely, diligently, and appropriately to give her patient, Miss Williams, the best chance at a recovery. This isn't Dr. Lewis's fault. This isn't a case about delay, and it's certainly not malpractice. And with that, I would like to introduce you to my client, Dr. Esther Lewis. Dr. Lewis is a board-certified emergency medicine physician. She has over 20 years of experience in emergency medicine, treating patients in Prince George's County, just like Miss Williams. She's trained and experienced in treating stroke patients. Dr. Lewis is with us today. She will be with us all week. And Dr. Lewis will testify, and she will tell you, ladies and gentlemen, about the care that she gave Miss Williams, how it was reasonable, why she did what she did. And you'll see, Dr. Lewis is experienced, competent, and caring. We're going to be talking a lot about some heavy medicine here. Basilar artery clots, basilar artery strokes. What is that? It is a devastating stroke in the back of the brain. A couple things that I want you to know about a basilar artery clot. First, they're rare. This is not the typical type of stroke presentation that these emergency medicine physicians see. Second, and most importantly, they are devastating. They are associated with high morbidity and mortality, even when treatment is attempted. You'll hear that these types of clots are like a bullet to the brain. Ladies and gentlemen, this is a very emotional case about the untimely death of Miss Williams' mother. We feel sympathy for Miss Williams and her family, and there's no doubt that you'll feel that same sympathy too. But what I'm asking you, ladies and gentlemen, is that when it's time to decide this case, I want you to take that sympathy, put it in a box, and put the lid on that box. And when you're deliberating, make your decision about Dr. Lewis's care, not about the sympathy that you certainly feel for Miss Williams and her family. Now let's talk about that care that Dr. Lewis provided to Miss Williams at Prince George's Hospital on June 24th of 2020. Miss Lewis arrived at the emergency department at 9:30 a.m. She had a rapid heart rate and she was dizzy. An EKG was performed and confirmed she was in atrial fibrillation with rapid ventricular rate. Dr. Lewis evaluates Miss Williams. She provides metoprolol, which is a medication to treat that rapid heart rate. Shortly after that time, Miss Williams has 2 nursing evaluations. And as part of that nursing evaluation, there is something called an NIH stroke score assessment done. And those NIH stroke scores, both times, 0. That is a totally normal exam, not indicative of a stroke. Dr. Lewis comes back at about 12:41. She evaluates Miss Williams again, and adds another medication also properly to treat that heart rate. About 30 minutes later, and this is important, Dr. Lewis again evaluates Ms. Williams, and this time she performs her own neurologic assessment, assessing for potential signs of stroke. Totally normal. So what's important here? Before that 2 p.m. time frame, there are no signs and symptoms of a stroke. How do we know that? At 11:10 and 12:34 p.m., neurologic stroke assessments, 0, not indicative of a stroke. And then at 1:07 p.m., Dr. Williams herself performs a neurologic assessment, and she also has a totally normal exam at that time. We know, and you'll hear a lot about this, that at 2 p.m., there is a change in Ms. Williams' condition, and this is important. Ms. Williams has some facial droopiness and some arm weakness. The family alerts nursing, who then tells Dr. Lewis. Dr. Lewis comes to evaluate Ms. Williams. She recognizes that this is a stroke presentation, and this is what she does. She calls a code stroke. She orders a stat CT to evaluate. She calls the on-call neurologist, who is the specialist in stroke, for a consult. And at the direction of that neurologist, she orders an MRI. This is all done within 15 minutes. This is appropriate, timely, and within the standard of care. We know that at 4:14, the MRI results come back, and they indicate that that is a confirmed stroke. Dr. Lewis again jumps into action. Dr. Lewis calls the neurologist again. The neurologist tells Dr. Lewis to give Ms. Williams some aspirin and admit her to the ICU. So Dr. Lewis does that, but Dr. Lewis doesn't stop there. Dr. Lewis wants to know if there's anything else that can be done for her patient. So she calls University of Maryland to see if there's anything that they can do there that Prince George's County doesn't have the ability to do. That's called an endovascular clot retrieval. So she calls University of Maryland. Unfortunately, they do not accept Ms. Williams as a patient. They don't have a bed available, and they've requested additional imaging called a CTA. So Dr. Lewis orders that study. But again, Dr. Lewis doesn't stop there. And Dr. Lewis will testify this. She called 3 or 4 additional centers to see if she could get a quicker transfer for Ms. Williams to undergo this clot retrieval. Unfortunately, none of them accepted Ms. Williams without this study. By 7:30, the study comes back. Dr. Lewis is again on the phone with University of Maryland, and at that time, fortunately, Ms. Williams was accepted as a patient. Dr. Lewis then arranges transportation to University of Maryland via helicopter, and Ms. Williams arrived at University of Maryland and underwent that clot retrieval. We know, unfortunately, that that clot retrieval was unsuccessful, and sadly, Ms. Lewis died. At the end of this case, ladies and gentlemen, you will have to ask yourself 2 key questions to determine whether there was medical malpractice, negligence, in this case on the part of Dr. Lewis. And that first question is, was Dr. Lewis's care reasonable? And you will hear, ladies and gentlemen, in support of Dr. Lewis, an emergency medicine physician expert, Dr. Van Horn. Dr. Van Horn is a professor of emergency medicine at Harvard Medical School. And she's also chairman of the emergency department at Brigham and Women's Hospital, which is affiliated with Harvard. And what does Dr. Van Horn say? Dr. Van Horn completely supports the care provided to Ms. Williams by Dr. Lewis. She called a code stroke immediately as soon as there were signs and symptoms of a stroke. She followed all the stroke policies and protocols at her hospital. She obtained all appropriate studies and consulted the appropriate physicians and transferred Ms. Williams as soon as she was accepted, giving Ms. Williams the best chance at a recovery. This is not a delay. This is not malpractice. The second question, did Dr. Lewis cause Ms. Williams' death? Dr. Lewis did not cause the death of Ms. Williams. Her devastating clot in the back of her brain did. She had a large clot in the basilar artery, and you'll hear this, it's like a bullet to the brain. And unfortunately, these clots are associated with high morbidity and mortality. It was the clot, not Dr. Lewis. Ladies and gentlemen, the plaintiffs and the defendants in this case do not come here in equal footing. It is the plaintiff's burden of proof to prove to you both that Dr. Lewis breached the standard of care, that she was unreasonable in her care of Ms. Williams, and that it was Dr. Lewis who caused the death of her patient, Ms. Williams. I submit to you that they will not be able to meet that burden. We understand, of course, that this is a very important case for Ms. Williams and her family. But this is also important to Dr. Lewis. Dr. Lewis takes pride in the work that she does and the patients that she cares for in Prince George's County. And at the end of this case, I'm going to ask you for a defense verdict on behalf of Dr. Lewis. Thank you.
Thank you for joining us today. Tomorrow we will hear the plaintiff's case. See you then.